is a certified Sharia advisor and auditor from AAOIFI, an alumni of Al Azhar University, and a Fulbright scholar who is currently pursuing his Master of Law degree. Please welcome Brother Mahmoud.
Bismillah, salatu wassalamu ala rasulillah. Assalamu alaikum. It's actually a huge honor and privilege to be presenting here in front of you today. One of the most important subjects that affect the growth of Islamic finance. This is actually my first time to present in a conference, so I might be a little bit nervous, but I'll try as much as possible to do my best. As brother mentioned, I graduated from Al Azhar University from Faculty and Sharia and Law, the English department. And I worked in banking sector in Egypt for about 3 years. Through that period, I got my certified as a certified Sharia associate and Sharia advisor and auditor from IUFI. I'm currently pursuing my international business and economic law master's from University of Southern California Gould School of Law as a Fulbright scholar. So to begin with my subject, why actually do we need Islamic finance? Well, riba is a prohibited deal in Islam. So Muslims do not wish to deal with interest-based financing or interest-based financial institutions. So the need then arises for Islamic finance. People need Islamic finance, Sharia-compliant way of financing in order to deal with with banking in more relief in that regard. There is actually a huge market need for such financing with around 2 billion Muslims all around the world. So the international financial system need to be more flexible, accepting all of these new revolutionary banking system. So what makes Islamic banking is different? Actually, brothers in here in the conference really did a great job emphasizing this, but I will only discuss 2 points. First of all, investments. Conventional banking is actually only interested in interest-based loans, while in Islamic finance, it's profit and loss sharing way of methods, and also risk sharing. So this is a huge difference between them both. And the second one is the structure. The conventional finance is basically a loan contract. Whatever it is, from the small scale to the larger scale to the syndication to whatever the kind of finance, is simply a loan contract. However, when it comes to the structure in Islamic finance, it depends on the thing that you want or the product that you want to finance. So if it is a house, it will be musharaka, dimensioning musharaka or ijara. If it is a car, it will be suitable for murabaha. It would depend on the product, not just loan contract. So what is the impact of promoting Islamic finance? First of all, inclusion. 2 billion and a huge number of persons, Muslims, here in this planet, do not wish or do not feel comfortable dealing with conventional banking. That's why we need Islamic finance in order to make them feel free and included when it comes to financial and banking, and have more access when it comes to banking system. And the second one is Islamic finance is ethical. So it actually reflects and satisfies the people's real need. And the last one is sustainability. When it comes to Islamic finance, it is more sustainable when it comes to as an Islamic financial solution. So how can we actually make this great way of financing grow more and more? First of all, we can have better risk management, or even strong Sharia compliance and governance. But most importantly, and it is the one that I'm going to discuss here today, it is having suitable and sustainable dispute resolution mechanism. So what do I mean by that? When it comes to litigating or having disputes over Islamic financial contracts, it has been proven, and this is spoiler alert, litigation is not the best way, especially in a cross-border or Western courts or litigation. So what I mean by that? So I simplified a case for you. If a bank in Islamic bank in Emirates, say the United Arab Emirates, financed a business in Singapore, and they chose English law as their governing law to this contract. So what would happen if a dispute on this contract is actually arised? So this is might be like a sample of the governing laws that govern between the party, as you see here in the first yellow highlighted one. English law will prevail over this contract as long as its provision are consistent with Islamic Sharia. So if a dispute happened on this governing law, first there is a convention called Rome Convention 1980. This convention related to the contractual parties. So this convention actually explicitly mentioned that the parties to the contract would have freedom when it comes to choosing their governing law. However, they only can choose one governing law. They can choose two governing law. So they can choose the laws of the England and the laws of New York State or whatever. They only got to choose one governing law. Actually, English courts considers Islamic law as non-national law. So if it happens that English law are conflicting with Islamic law, the English law would prevail. English courts will disregard Islamic law from this governing law, and the they will disregard Sharia law from this dispute, and only Sharia English law will prevail on this contract. And that's exactly what happened in a very famous case called Beximco case. So there were a bank in Bahrain called Shamil, and there were a pharmaceutical company. I guess we have a lot of people here from Bangladesh. This is actually a Bangladeshi pharmaceutical company. And a dispute arose between those parties, and the English law was the governing law for this contract. So what happened is the English court disregarded the Sharia law as a governing law over the contract and only applied the English law over the disputes, transferring the contract from a Murabaha contract, and it was around $50 million contract, to an interest-based one. This is actually considered a serious violation of the intentions of the parties, transferring their Islamic financial compliant and Sharia compliant contract to an interest-based one. And you can imagine Sharia boards will not be happy in that regard. Investors, or even the shareholders, or even the depositors of those banks who trust this bank as an Islamic bank. As we mentioned, they transferred the contract to the conventional loan, and they applied the English law in that regard. So how to find a better solution for this option as English law or New York law? And those laws are the most disputed when it comes to financial contracts, especially the international aspect. They are really famous because everyone knows them, the lawyers, and even the board of directors. So they like English law and they like New York laws. Actually, there is a very important solution for this, which is arbitration as an alternative dispute resolution for Islamic financial contracts. So instead of going to English court or English judge or New York court or New York judge, you can appoint your own arbitrator. So why arbitrator? Why arbitration? Arbitration has three very good characteristics that comply with Islamic finance. First of all is enforceability. And second is specialized expertise. And finally, the party autonomy. First, what do we mean by enforceability? Once the award in arbitration is issued, the award is final. And what do we mean by final? If we went to Texas court in here, if you want to go to dispute over the contract, you would firstly go to a trial court, which is the first instance court. And the second court would, if you don't like this judgment, you go to appeal this to the appellate court. And if you don't like this, at certain circumstances, you would actually go to the Supreme Court. So you can have appeal over this contract. However, in arbitration, once the award of the arbitrators are issued, it's actually final. You cannot appeal this one. Another thing when we talk about enforceability is a convention in New York called New York Convention for it's just for the enforceability of arbitration agreements or arbitration awards. This convention allows the party countries of this convention to enforce the arbitration award from all over the world to this country of the defendant or the one who lose the award. And there is around 172 countries actually parties to this convention. So you can ensure that if you got an award in New York or England, you would enforce this one in Egypt, in Emirates, in Malaysia, in Singapore, whatever, as long as this country is party to the New York Convention. So the second one is specialized expertise. And what do we mean when we say specialized expertise? It is arbitration give the parties the freedom to appoint their own arbitrators. So those arbitrators can be actually jurists or experts in Islamic finance, which would make the dispute resolution even more compliant when it comes to disputing those Islamic financial contracts. The last one is party autonomy, which is one of the specifications of the arbitration as an alternative dispute resolution. It allows the parties to choose their applicable law, which is the one that why we reverted to arbitration from the first place. It actually allows the parties to choose their applicable law, whether it is the subject matter law or even the jurisdictional law. It also allows the country to choose the language when it comes to the procedures. So when the award is issued by the arbitrator, you can even choose the dispute is going to be in Arabic, in English, whatever the language it is. So this is a sample of how the clause would be like when it comes to arbitration. Please do not code this one. You need to consult your own legal counsel. So actually in here, it says that this contract shall be governed and interpreted based on in accordance to provisions of Islamic Sharia and the standards of IUFI and the resolutions of the Sharia boards of the participating bank. This is a syndication contract. And in syndication, there is more than one bank. So all the resolutions of those Sharia boards would be applicable to this contract and actually would be arbitrated in case of arbitration. And as we see in the very last paragraph, the New York law would apply. So you can do that in arbitration. You can have standards of IUFI, and at the same time, New York law would apply. And imagine what, in arbitration, no one would disregard your laws because they don't like it. So right now, there is arbitration venues that adapt Islamic law and their bylaws or through their articles of associations, such as the International Islamic Center for Reconciliation and Arbitration, or the Asian International Arbitration Center, or the International Mediation and Arbitration Center. So what would happen if we promoted arbitration as an alternative dispute resolution when it comes to Islamic finance? First of all, it would gain the confidence of the investors when it comes to depositors, when it comes to shareholders, when it comes to Sharia board supervisory boards. Because if you gain the word when it comes to, and it was a conventional court and transferred your contract from Islamic compliant contract to a conventional contract, the Sharia boards will not be happy about that, and this money might at the end go to purification and go to charity. You won't even add this money in your general ledgers as a profit. And the second one, arbitration is actually making the dispute resolution more even more compliant when it comes to disputes. So instead of going to English judge or New York judge or Texas judge, who is appointed actually by his government, who actually do not know that much about Islamic law, you can appoint your own arbitrators who are experts or jurists when it comes to Islamic law. Finally, it's internationally enforceable. As per New York, it guarantees that those awards will be enforced on the parties' countries. And once the award is issued, it's actually final. So no one can appeal on this awards. So to conclude, Islamic finance actually has a potential growth, as a lot of presenters mentioned. It is reported by, I guess, Standard Chartered that Islamic finance assets in 2016 was around $2.8 trillion, and by 2026 it's going to reach around $5 trillion. So it is doubled on this very small period of time. So it is actually has a huge potential of growth. And to ensure that this growth would even be more Sharia compliant and will not be just a growth, but when it comes to court, we would apply conventional laws and would transfer the contracts from Islamic-based contract to conventional law. We need to apply alternative dispute resolutions, whether they are arbitration, mediation, or reconciliation. But we need to make sure that those that growth would actually comply with Islamic Sharia. And one more thing is the intention of the Islamic institutions to actually adapt and settle their disputes based on Islamic law. And this is actually very sad when it comes to such point, because it is reported by the International Chambers of Commerce in Paris that board of directors of Islamic banks are actually reluctant to dispute their contracts based on Islamic law, or even their standards or of the resolutions of their Sharia boards. So the intentions of those boards need to be existence to dispute those contracts based on Islamic law, not just the laws of conventional loans or conventional countries that are Western, actually. We need actually to open more international dispute resolution centers, arbitration centers, mediation centers, in order to make sure that our contracts, Islamic financial contracts, actually comply with Sharia law. And another thing is standardized arbitration and mediation and reconciliation on Islamic financial contracts, in order to make sure that they don't go to litigation or courts, ordinary courts, and they transfer them from Islamic financial contracts to just basically loan contracts. And the international Islamic financial markets for derivatives and all of the derivatives and hedging is actually standardizing arbitration as an alternative dispute resolution mechanism on their contracts instead of litigation. And with that, I conclude. And please, if you have any further questions, I'll be happy to address them. Thank you very much.